So, welcome back to Intellectual Property Class 3, in which we're going to begin our discussion of trade secret law, specifically talking about what a trade secret is and how we determine whether or not trade secret protection actually applies to particular information. And keep in mind that trade secrets are, in some respects, related to the misappropriation of information tort that we discussed in the last class, but they're different in some really fundamental and important ways. Specifically, the main difference is that trade secret information has to be secret information. So confidentiality is really essential to trade secret protection. So as the trade secret as trade secret law generally states, right? Trade secret law means information that derives economic value from being secret or from not being readily ascertainable, and that the person who's in possession of that information actually makes efforts to keep that information secret. Now, of course, trade secret law is protected by a wide range of different laws, both state law and federal law. Recently, there was a federalization of trade secret law. So, there are meaningful differences among the states as to the scope and application of trade secret law. But broadly speaking, we'll sort of be looking at it as a kind of general overview as to how trade secret law applies. Broadly speaking, and it's generally going to be applicable in most places. So the key point here is that in order for trade secret law to apply to any piece or category of information that's owned by a business, it has to be information that has economic commercial value of some kind for a business, and information that business is actually investing energy in keeping secret and maintaining confidentiality of that information sufficient to justify application of trade secret protection in the first place. So, why then do we have trade secrets, right? I mean, if information is secret, if it's confidential, why do we need any kind of protection, right? I mean, why not just say to businesses, well, gee, if you have secret information, you want to keep it secret. As long as it's secret, then it's protected because no one knows what it is. And if it's not secret anymore, then you're out of luck. You can't object if somebody figures out what it is. Well, the problem here is that in many cases, secret information is really only economically valuable if and when and how the business can share it with its employees and other insiders to the business in order to engage in economic activity on the basis of that information. In other words, the real point of trade secret law is to identify when information is confidential with respect to insiders to a business, such that insiders to the business who become privy to that information have a legal obligation not to disclose it, and people who obtain it by improper means from insiders are also prohibited from engaging in using that information for their own economic benefit. In fact, in many respects, you might kind of think of trade secret law as a little bit like insider trading law to some degree, right? In the sense that what we're really talking about is to what extent do the people who have access to information that belongs to a company, like fiduciaries or confidants of a business, have an obligation to maintain the secrecy of the information that business provides to them? And how do we determine what kind of information is protected and what kind of information isn't? So the first case that you read for this class was Imokalee Laird. This is a 1993 case from Indiana. And the background here is essentially that the Imoka Oil Company was engaging in oil prospecting activities in the Midwest in about 1991. And among other things, they had their employee, John Clendenning, who was a geologist, sort of in charge of at least part this project. And Clendening was a big proponent of a new technique that was known as a microwave radar survey exploration. And so he commissioned a microwave radar survey of a particular area of the Midwest that he determined was likely to have significant oil reserves. Cost about $150,000, which was billed to the company, and it identified some, potentially promising sites. But at that particular moment, it didn't look like it was going to be economically viable to pursue them. And so Imokalee kind of tabled the information and said, well, maybe we'll pursue that in the future, but at the moment, this doesn't look like something we want to go after. Well, Clendening wasn't very happy about that. He was a big proponent of this technique. Apparently, he wanted to push the technique, and he wanted to prove that he was right, that this technique was going to be identifying where oil deposits were located. So ultimately, he passed some information that he had generated through these surveys, among other things, to a fellow named Laird, who then went out and on his own did some additional looking around, hired a dowser, as you'll see pictured in this photograph. This is a generic dowser, not the specific dowser used in this particular case. But nonetheless, Laird hired a dowser and sort of looked over the information and said, this looks promising to me. I'm going to go out and buy up some oil and gas leases for the areas in question in order to kind of speculate on the possibility that there will in fact be oil deposits there that will be economically viable in the future. Well, as we know today, turns out lots of economically viable oil and gas deposits in the Midwest. And very shortly afterward, in fact, later in 1991, Imokalee changed his mind, decided, hey, maybe we'll go and try doing some exploration in these areas after all. And lo and behold, turned out Laird had already bought up all of the most promising leases in the area, and didn't take much for Imokalee to trace this back to Clendening and realize that, oh no, our employee went and told a third party about this information that we generated, and he's gone to beat us to the punch and bought up these leases that we could have bought at the time, but we thought we didn't need to, because we thought this was confidential, economically valuable information that we were trying to keep secret. Therefore, we thought we could kind of keep it hush-hush and buy up the leases in the future at a time when it makes sense. So what did? They brought a trade secret infringement action against Laird, right? Why? Because their argument was essentially, look, Laird has misappropriated this information through Clendening, right? Laird should have known that Clendening was not permitted to give him this information, and therefore by obtaining this information, Laird was in a sense promoting or encouraging or benefiting from the improper activity that Clendening was engaging in, right? In other words, Laird isn't allowed to benefit from Clendening's misdeeds because Laird participated in the misdeeds himself. Essentially, Laird's defense is, look, this isn't secret information in the first place, right? I mean, you decided what areas to prospect and so on by going to the national, the geographic survey and looking at maps and figuring out, kind of what geographic formations look like that might have oil in them, et cetera, et cetera. I could have done the same thing, right? It's economically feasible and ascertainable for me to go and do the same kind of stuff. So this information is publicly available, right? I mean, all the raw data's out there. All I had to do was, grab the information, run the numbers, and, I could have made the same decision on my own. The fact that Clendening tipped me off is totally immaterial. Who cares, right? It doesn't make any difference, right? I mean, it's the kind of thing that I could have figured out on my own. And the intermediate court actually agrees with Laird, saying, look, it was economically feasible for Laird to figure out where the oil might be on his own. And because it was economically feasible, effectively that makes it general knowledge. Therefore, even if Laird got the information in some improper means, he could have done it another way, and so who cares, right? It doesn't make any difference. You can't claim exclusivity, and you can't blame Laird for improper behavior if he could have gotten the information elsewhere. Well, the Indiana Supreme Court reverses and essentially says, look, the economic feasibility test that's adopted by the intermediate court, that's not the way we should be looking at this. What we should be saying is, look, is that information already readily available elsewhere? Right? In other words, could Laird have just gone out and found that information on his own? Or would he have actually had to invest resources in developing that information and making decisions based on that information such that he would have been able to figure out where the oil deposits were independently of any of the investment that was made by Imokalee? And that was really kind of decisive for the case right there. Because the reality is that Imokalee had in fact invested a great deal of research effort in interpreting the maps before even doing the surveys in the first place. Plus, it had spent $150,000 on these microwave surveys, which at least arguably confirmed to Imokalee that these were likely to be viable oil deposits for drilling. And so under the circumstances, Laird really couldn't argue that this information was readily available. After all, the analysis that Imokalee engaged in of the publicly available information was available only to Imokalee, and the test results from this study were in confidence and also available only to Imokalee. So ultimately, Laird's decision was based on this confidential private information that belonged to Clendening, not based on the public information that was available to anyone, right? So then the question really becomes like, how should we think more broadly about, accessibility or availability of information? What makes information publicly available such that the claim to privacy or the claim to confidentiality asserted by a company is or is not a viable claim for trade secret purposes? Well, and more than that, sort of, what are we trying to do when we think about trade secret protection? In other words, who are we trying to protect? And more to the point, what are we trying to prevent? And there's a lot of different ways of thinking about that, right? So on one level, we could say, look, this is really about commercial ethics, right? It's about preventing unfair competition. It's about saying, look, Laird, you're in effect improperly obtaining information from an insider to Imokalee. We don't think people should engage in that kind of activity. And we're going to use trade secret law to tell you that you can't and shouldn't be able to engage in that kind of clandestine activity. We're going to use trade secret law to prevent you from obtaining improperly this insider information that belongs to Imokalee and that Clendening shouldn't have been disclosing in the first place, right? So there's a kind of, a potential kind of ethical, moral valence to trade secret law. But of course, there's also maybe arguably at least some consequential justifications, right? I mean, maybe trade secret protection will provide an incentive for companies to invest in generating this kind of information in the first place. I mean, after all, if Imokalee knows that it can't keep this information secret and that its employees could go spill the beans to anybody, well, it might not invest in this activity in the first place. And, more broadly speaking, in areas of endeavor that we might consider more socially desirable, perhaps, than oil prospecting, right? We might see a decrease in investment in the generation of information that might be, protectable as a confidence, even if it isn't protectable in other means, like say, e.g. via patent protection, right? So maybe protecting trade secrets can have some kind of knock-on innovation encouraging effects that we might think are valuable. And then finally, maybe there's just a fairness question, right? I mean, maybe we want to say to companies, look, if you invest time and energy in generating confidential information and trying to keep that information secret, it's only fair that we should provide you with some kind of framework that would enable you to maintain the value of the investment that you've made. And it's just unfair to let people engage in this kind of predatory activity. Irrespective of what we think about the ethics of it, it's just wrong, right? And we think we're going to prevent them from doing it, no matter whether or not the business thinks, or the business milieu, more broadly speaking, thinks that this is appropriate behavior. Okay, so how do we think then about what kind of information might qualify as trade secret information in the first place. In Imokalee Laird, right here we have a situation where the business has invested significant resources in generating information that it really is keeping secret. And the question is, can third parties benefit when, or can and should third parties be able to benefit when insiders, employees spill that information? What about the employees themselves? And to what extent should the business be able to use this sort of confidentiality, or maybe pretense of confidentiality, to prevent employees from competing with it? So in the case of CDI Energy Services v. West River Pumps, right? So CDI is an oil services company based in North Dakota, or at least this particular division is in North Dakota. And several of CDI's employees in North Dakota decide to leave CDI and start their own company, right? And they start West River Pumps. They start competing with CDI. And unsurprisingly, CDI is not thrilled about this, right? Nobody likes competition. And here it is, their own employees competing against them, using a lot of expertise that the employees developed while they were working for CDI. In particular, CDI says, look, we trained you how to do this job really well, right? Like you spent a lot of time working for us, and we trained you on all of our procedures and processes and helped you understand how to go about like pitching and selling the kinds of services that we're providing. And more than that, we have customer lists. We have all kinds of data that we've developed in the course of running this business. And you're using that same information, right? You're going to the same customers. You're trying to pitch them better services, lower prices, et cetera, et cetera. This is totally unfair. You're our former employees, and you've got all this information that you got from us that you're not supposed to be using on your own to do your own thing. And so the question is this the kind of situation where CDI can bring a trade secret infringement action in the first place? And fundamentally what this case is really about is this information really secret, right? I mean, CDI says, look, we generated this information, we keep this information in-house, right? It's valuable information about the business and so on and so forth. And they've, our former employees have gone and they're using it without our permission. And the court essentially says, look, anyone in the oil services business in North Dakota knows who the customers are, right? I mean, they're all out there. They've got their oil rigs going and pumping, and your employees are in the business. They've learned this kind of stuff in the business, but that's part of being an oil services company employee. These are skills that they've developed themselves. They know just as well as anyone else who the customers are. They didn't need to get your list. They could figure that out on their own. None of this is secret information, right? I mean, this is valuable information because you gathered it together, right? But the point is, it's not secret. It's all publicly available and could be gathered together by anyone who want to do it. And in fact, in a lot of, in some sense, the employees who left kind of had this information sort of baked into their experience of doing the job in the first place. And I think one of the nice things about this case is it really kind of illustrates the sort of discomfort courts have with the idea of saying former employees aren't allowed to use information or skills that they developed in one employment situation in a new employment situation, right? Of course, CDI wants to not have competition. It doesn't want its employees to start new companies and start competing with it. But essentially what it's saying is like, look, we trained you, therefore you're obligated to either work for us or not work in the business at all. And the court is essentially saying, no, that's not how it works, right? They learned how to be oil services employees, and they're perfectly entitled to quit your business and start their own business. And you can't stop them from doing that simply by saying, we trained you and we taught you how to do this, right? If you want to bring a trade secret action against them, you've got to show not only that they're using valuable information, but that they're using information you're actually entitled to exercise exclusive control over. And I think that's really the problem here, right? Is that CDI wants to exercise exclusive control over information the court doesn't think it's entitled to have exclusivity over. Right? Now, on one level, maybe the problem is, well, they didn't maintain sufficient secrecy of the information. But one wonders, is there something they could have done, with asking the employees to sign an additional agreement saying they would maintain secrecy? Should any of that matter? Or should we look at the substance of the actual information in question and say, look, it would be anti-competitive under the circumstances to say that the employees shouldn't be able to take that information and use it in their own business, right? I mean, this is information that even if it would take some time and energy for them to synthesize it, they need it. It's essential to being a business, and it's the kind of thing that just isn't secret in the way we want it to be secret, just isn't confidential in the way we want it to be confidential, just isn't possible to maintain as a form of secret information in the relevant sense. Okay, so one key principle when it comes to trade secret law is the concept of reverse engineering. And essentially what reverse engineering says is that, yes, trade secret law protects confidential information when the owner of that confidential information makes efforts to maintain the confidentiality of that confidential and commercially valuable information. But if other people can figure out that information on their own without access to improper means, i.e., without essentially relying on insiders to tell them what that information is, then that's perfectly permissible, right? And one of the ways that you can find out secret information is by way of reverse engineering. In other words, one of the reasons or one of the ways that companies use secret confidential information is to produce products. And oftentimes that information is sort of encoded in the product itself. And therefore other companies can look at the product and by looking at the product, figure out what the secret information was that was used in order to generate the product in the first place. And that's what's really at stake in this case. So what happened, right? Cementech, 3D Industries, there are two different Iowa companies that are engaged in like cement mixer production in various ways, right? They consider a merger at one point. They're thinking about getting together. Doesn't happen. Some Cementech employees are then hired by 3D, right? And Cementech has a brand new cement mixer in the market. It's like revolutionary, according to them, cement mixer product. And lo and behold, shortly after these Cementech employees are hired by 3D, all of a sudden 3D comes out with a clone of this brand new Cementech mixer. And Cementech says, oh my God, right? They're totally stealing our trade secrets. This is really bad, right? Well, the district court, they file an action against 3D. The district court rules in favor of 3D, saying that there's no material issue of fact, right? This is just, there was a mixer, they looked at the mixer, they figured out what the mixer does. End of story, right? No problem, right? They looked at the mixer and that was enough for them to figure out how the mixer works so they could make their own product. Cementech responds that no, there is an issue of fact, right? And what's the issue of fact according to Cementech? They say, look, yes, it's true that given enough time, 3D Industries could absolutely have reverse engineered their product from ours. In other words, they could look at our product and figure out what the trade secrets are such that they could manufacture their own product. Yes, we totally concede that given enough time, they could accomplish that. The problem was they did it too fast, right? Cementech's entire argument here is, look, reverse engineering is time consuming. It's hard work and it takes a lot of energy. Right? And essentially part of what they were relying on was the premise that their secret information would be hard enough to reverse engineer that they would have a significant market jump on competitors like 3D. And essentially what they say is, look, 3D figured out how to reverse engineer this product way too fast. And the only reason they were able to do that is because they hired one of our employees who had access to confidential information. And that confidential information was what they needed in order to jump the gun on producing the product. In other words, they could have reversed engineered it, yes, but they didn't. Right? They didn't reverse engineer it. They actually got the trade secret information by improper means that enabled them to do it faster and that enabled them to have an advantage, or rather less of a disadvantage over us by virtue of the fact that they were able to get their product, their competing product on the market faster. And that's our allegation of trade secret infringement. Not that reverse engineering wasn't possible, but that reverse engineering would have taken much longer than it actually took them to produce the product in question. That's a question of fact, and we think that we should have been able to go to the jury on that. And the Supreme Court agrees. It says, look, that might be true, it might not be true. You got to prove that that reverse engineering wouldn't have been possible in the time frame at issue. Okay, finally, in a DVD Copy Control Association v. Bunner, DVD Copy Control Association was essentially a DRM company, right? What they did was, or digital rights management company, what they did was they create code for various kinds of content producers that prevents the copying of DVDs. I know those are a bit of an anachronism today. Back in the day, DVDs were a big deal, right? And companies were worried that consumers were going to be creating digital copies of programs and movies and music and so on and so forth. And they wanted this kind of DRM protection to prevent people from being able to make copies. That was the purpose of this code. So the DVD Copy Control Association generated this content scrambling system, or CSS, which is basically a form of DRM, which if you tried to copy something, basically would turn it into like a scrambled eggs, turn alphabet soup. It wouldn't mean anything anymore. It wouldn't work, right? So the idea was that this would prevent copying, and it came along with a license associated with the products in question that said reverse engineering is not permitted. In other words, by virtue of buying or licensing this product from us, you agree that you're not going to reverse engineer it, and as a consequence, you're not going to look into the underlying CSS code that will prevent you from making copies. Well, lo and behold, in like 3 days, some hacker, no one's exactly sure who did it, although there's a lot of speculation, went ahead and reverse engineered the code anyway and came up with a code called DCSS, or CSS descramble, and basically just sent that out all over the internet. And as you know, of course, once something's on the internet, it's forever. It was never disappearing at that point, and people were spreading it all over the place. Of course, the content producing companies were absolutely mortified and livid, and did their damnedest to prevent people from distributing it. Unsurprisingly, to no avail. People were sending it out all over the place. Among other things, they were producing, so the content companies were trying to force people to remove the code from their websites. And so the various people on the copy left came up with a bunch of amusing sort of rejoinders, including this T-shirt that included the code for DCSS as like a graphic image. I believe there was also a DCSS tie you could buy that included the code on it as well. But they were very upset. It was actually a remarkably short piece of code to descramble the CSS encoded material, and they brought an injunction against Bunner, among others, to try to prevent him from continuing to distribute the material, arguing that, well, look, this is trade secret information, right? It's confidential because it's code. We didn't release it to anyone. We kept it secret, and we did our dangest to prevent people from disseminating it, right? And we had people like form a license and say they wouldn't reverse engineer and promise not to do it, and we kept it secret and we didn't tell anyone about it. And what else could we possibly have done to prevent the dissemination of this information? And the court's response was, well, that may or may not be true with respect to the people who actually did the descrambling, but by the time Bunner got it, this wasn't secret anymore. Everyone on the internet knew it. It was everywhere. It was widespread, no secret remaining whatsoever. You can't assert trade secret protection just because you tried to keep it secret if it turns out the information was already not secret by the time a third party got it. And what's more, Bunner had no duty to you. He had no relationship to you or to your customers. He had no obligation to keep this material secret, and you can't stop him from disseminating publicly available information. Therefore, no trade secret for you, DVD Copy Control Association. You're out of luck, and anyone can disseminate this to the extent that they want to. Okay, thanks a lot.